Are you struggling to remember case law? It's because you're going about it the wrong way. Hi, and welcome to the Law Simplified, the world's largest independent online law school platform. I'm your instructor, Shaveen Bandadanaike. The number one question that I get often asked, whether it be on this particular YouTube channel, the online law school platform, or even when it comes to my first year fast track and masterclass law students, is how on earth do I remember all of this case law? If you like the type of content that I make on this YouTube channel, as well as the different platforms the Law Simplified is disseminated on, do subscribe and post a comment below so that I have an idea of what more that I can do to help you on your academic and career progressions in law. Now, this fundamental question seems to, on the one hand, plague students, and for those of you who become anxious as to seeing the case law and the volume of case law at that, and being unable to cope with the material. One solid way to get over this hurdle is what I like to refer to as the fingerprint technique. What do I mean by this? If you have a smartphone, either an iPhone or an Android device, chances are you've already set up your fingerprint in order to unlock your device. And you may have come across this particular screen where they ask you to give your thumb or your index finger print onto the screen. And it's not just the fact that you're supposed to do it once, but they ask you to do it constantly. They'll ask you to move it about to the left and the right, the top and the bottom, go around the periphery of your fingerprint as well, until they have enough information in whatever format that you do place your fingerprint on that device. It'll be able to recognize that it's you and unlock it. This particular technique is exactly the same in terms of applying it to understanding on the one hand and then applying case law. Now, on a number of occasions on this very YouTube channel, as well as the different platforms the Law Simplified is disseminated on, specifically when you have a look at the comprehensive pre-recorded masterclasses for the different modules that I've taught over the years, which you can access through the online law school platform, as well as via the subscription system that's available on there as well. I have spoken ad nauseum about the importance of practice, and more practice. In terms of the best and oftentimes most comprehensive way to keep in check all of the cases that are necessary for any particular topic, even a subject at that, it's really about using it in the context that it's supposed to, on the one hand, and then looking at it from different perspectives and using it in others. Now, to illustrate what I mean by the fingerprint technique that you see on your smartphones being applied in practice to preparation, to study, as well as theorizing it in terms of an examination question, let's have a look at a practical example with one particular case in criminal law and how it can be applied in multiple different ways, distinguished, applied, as well as considered in order to make sure that it cements not just the name of the case, but what the case stands for, its principle, and its articulated expression in terms of an examination. So let's have a look.
Let's have a look at the 1981 case of R and Saunders. Now, for those who might be unacquainted with the case, R and Saunders established a threshold extension to what grievous bodily harm entails. Now, as some of you might know, in terms of either murder, in terms of a common law offense in homicide, there must be an intention to kill or cause grievous bodily harm. The usual case for defining grievous bodily harm was the Director of Public Prosecutions and Smith, or DPP and Smith, which established that grievous bodily harm equates to really serious injury. Now, over time, because there was a loophole and a lacuna in the law that was established, R and Saunders came along to widen that threshold to indicate that even where there is serious harm that's intended, that can be equated to grievous bodily harm. Now, much like what I just mentioned, the aspect of serious harm or grievous bodily harm may also be relevant in terms of the statutory offence of Section 18, contrary to the Offences Against the Persons Act of 1861. So Section 18 deals with the circumstance where there is an assault or battery that has been committed or occasioned that has led to grievous bodily harm, and being a specific intent offence, if, for example, the defendant had intended to kill or cause grievous bodily harm, that would fulfill the requisites of Section 18. Fun fact, if the person goes on to die, in other words, the victim or the complainant goes on to lose his life, this gets elevated to murder. So this nexus is then created between not just Section 18 of the OAPA of 1861, but also the common law offence of murder. So as a tether, as a link, you'll notice that it's essentially a fingerprint that you find in terms of R. and Saunders from 1985. Because not only do we prepare for a question when it comes to grievous bodily harm, but also it's applicable as a case and as a principle in itself in both an Offences Against the Persons Act question or scenario, as much as a common law offence of murder. This is why it's important that when you do prepare for cases or when you do study cases, try and articulate around the case as well. Namely, don't just look at the principle and the case from one tunnel vision perspective of a singular topic or area. Try and pick and study cases that have wide, much more expansive applicability throughout your course. This is merely an example for criminal law. You might find the same example or a similar context in tort law or contract law or any other civil area for that matter. Just know that when you use a definition and when you use a case, try and make it as ubiquitous as possible. Prepare for it from different angles so that, much like the fingerprint on your device in terms of unlocking a phone, this case also will enable you to unlock different possibilities and arguments irrespective of the topic that you're tackling.
Right. The fingerprint technique is something I've tried to impress upon my fast track and masterclass students over the past several years of tutoring. Irrespective of the subject that you might be pursuing and irrespective of the level of study that you are at, whether it is a diploma, a Bachelor of Laws, a GDL, or even an LLM program, it's very difficult for us to come into the context of not just understanding cases, but keeping it in check. More often than not, students tend to be able to remember what the case is, sometimes even what the principle and how it applies to a given scenario, but not the case name, which is quite unfortunate. Just like we tend to remember people based on the clique or based on the groups in which we have associated them. Maybe we know people from school, we know people from college, or even from work. Just as much as we associate certain characters and personalities from different parts of our lives, it's no different when it comes to case law either. As long as you are able to articulate where this case fits in, why it applies, and how it applies, and in some instances, if you want to go from a pass to an ace in law, how it can be distinguished in order to build an argument that is converse to that. That is where you'll succeed in terms of not just memory, but also the purest form of understanding in terms of the law. That being said, until the next time that we meet, have fun, stay safe, and as always, obey the law.